I don't know, should we get started? Yeah. So, hi everyone. I think a number of people have arrived now. And thanks very much. I can see that some of you have switched off your cameras and muted. Of course, you can keep your cameras on, but I think it's quite important to mute because we've got over 220 people attending. So first of all, I just want to say a very big welcome to you all. Thanks very much for attending our next afternoon update. And I know a number of you normally come to our event at the Law Society, so this is obviously slightly different for obvious reasons. But we're delighted to have you all here, and it's great that there are no numbers limits, which we obviously normally have. For those of you that don't know us, we're obviously partners, employment lawyers, and I'm just going to start off by giving you a few headline points about what we're going to do. So we're obviously looking at COVID-19 in the workplace, and a little more about us for those of you that don't know much about us. I've been in the field for over 25 years, in fact, specialising in just employment law, and we work with a team of barristers, our team barristers, who are brilliant and work collectively with us on a number of our cases. And I'll introduce you to a couple shortly that are going to be taking part in this. And the other thing to just say is that there is a chat option on here. So if anyone attending this would like to ask a question, if you just send a question on chat, we will try to take a look and see if we can address that during the course of this. We do have quite a tight time frame. So we're going to be looking at the COVID-19 in the workplace, mental health, stress and suicide, which is here in the next slide. And really the only thing to say is obviously the burning issue is the impact of coronavirus, and to say that if any of you here have felt that it's confusing and you don't know what to do, then you're not alone. I can only say that as barristers and solicitors, we have had forums that we've been working with and attending, and so much has changed on so many occasions now, and there is so much that isn't clear that I'm certain that you are absolutely not alone. So if you do feel uncertain of something, you're probably it probably will be because it simply isn't clear yet. Okay, so I will just press on to this slide, which basically, let me see if I can move that. Yeah, this just refers to the guidance that's available, much of which is continuously being changed. So it may be that you'll discover that some of the things, in fact, some of the cases that we've been advising on one day, the very next day, we've had to change the advice slightly. Bye. So. Good. Right, so I'm going to now pass on to our barristers. First, let me introduce you. We've got Ian Rees-Phillips from Six Pump Court, and we also have Paul Livingstone from Outer Temple. Now, I'm just wondering where my slides have gone. Let's see. My slide seems to have vanished. I don't know why that is. I can try to upload them again. In any event, Paul, can I hand over to you to talk about statutory sick pay?
Hi, thank you very much, Hina. Yes, I'll talk a little bit about statutory sick pay and some of the other sort of unique issues which arise out of coronavirus. At some point, the slides may come back, but if not, I will take you through them regardless. So first of all, statutory sick pay itself. So as you'll all know, usually in order to qualify for statutory sick pay, an employee must be absent from work due to incapacity. And the particular thing with regard to coronavirus is that on the face of it, where an employee hasn't been diagnosed with COVID-19 or exhibited symptoms, it's unlikely that their absence would meet the usual definition of incapacity, because there's not actually any reason related to their capacity that means they can work. However, because the government recognised the specific issues arising from coronavirus, they amended the regulations. So now the position is that someone is deemed incapable of work in circumstances where they are isolating themselves to prevent infection or contamination with coronavirus, and by reason of that isolation are unable to work. So two things are necessary, and it's important that you regard both of those things together. So the first is that they're isolating. That can mean being at home. It basically means that you're not going into work. And the second thing is that because of that isolation, you're unable to work. So crucially, where somebody is able to work from home, where they are an accountant or a solicitor or a consultant, and they're able to sit in their laptop in the office like lots of us are doing, they are able to work and they will not qualify for SSP. Whereas if you work in a bookshop which is closed, or if you work somewhere where you cannot work from home, then you can qualify. So the circumstances in which you are incapable of work are either A, if you are self-isolating, B, if someone in your family has symptoms and is self-isolating, meaning that you have to self-isolate, and thirdly, if you're self-isolating because your family member has symptoms and then you get symptoms as well. So that was the position until the 16th of April, a couple of weeks ago, and then the regulations were amended again to say that not only is it if you actually have symptoms and are self-isolating, but also if you are defined as being extremely vulnerable and at very high risk of severe illness, and you've been advised to what's called SHIELD, then you are also qualifying for statutory sick pay. So that's what's commonly started to become known as shielding. And the most well-known examples of shielding are where you have an autoimmune disease or a serious asthma or being in remission with cancer, something like that, where the government has told you you are not allowed to have face-to-face contact with other people because it's too much of a risk to yourself. I should note that importantly, although as an employer, that means that if your employee is shielding, you can give them statutory sick pay. As I'll come on to talk to later, you can also furlough shielding employees. And I think Ian's going to come later to talk about shielding a bit more. And just finally on statutory sick pay, one of the other changes is, as you all probably know, the previous position with SSP was that you were only entitled to it from the 4th day of incapacity, whereas now you're entitled to SSP from the 1st day of incapacity. Again, a brief reminder, because it can be easy to forget, is that statutory sick pay is only £95.85 per week. So if you, as an employer, have any sort of contractual sick pay, an employee is highly likely to try and to claim that, and you're highly likely to want to pay that, because statutory sick pay is not a lot of money to live on. So I'm going to move on to slide 9, please. On to annual leave.
Sorry, next slide.
Yeah, and the next one, please. Thank you. So there's a few tricky issues with regard to COVID-19 and annual leave. So one is this issue about whether workers can carry forward annual leave. So again, as you know, in normal circumstances, employees are allowed to carry over a certain amount of untaken annual leave into the next year. But what the government's done is it's amended the regulations so that if you weren't able to take your annual leave because of coronavirus, you can carry over up to your whole period of annual leave. And the main reason for that was that essentially they wanted supermarkets, for example, to be able to say to key workers, we can't afford you taking annual leave right now, but you can carry it over to next year and the year after, because we really need you to work at the moment. It's not quite clear exactly what it means that it's not practicable to take annual leave, but it can be something like if you're a key worker, if you're having to cover for other workers, or if you've been, if you're too sick to take holiday that year. Now, the normal rules apply in terms of taking annual leave to cover periods of absence. So we're in circumstances where you might otherwise have your pay as an employee drop to the statutory sick pay or to something else, you can take annual leave again. Now, one of the more vexing questions, and I say that because I know that there is quite a large amount of disagreement between pretty eminent QCs on both sides, is about whether an employer can require employees who are on furlough to take annual leave. Because obviously for an employer, if you've got employees that aren't doing any work and they're on furlough, you might think this is a perfect time for those employees to take annual leave because they're not doing anything for me anyway. So I can sort of reduce their entitlement whilst they're on furlough. However, the view taken particularly by Michael Ford QC and Alan Bogg, who are two of the experts on this area, they say that employees cannot be forced to take annual leave on furlough because they say that the purpose of annual leave, which is a right which derives from EU law, is to enable a worker both to rest from work and to enjoy a period of rest and leisure. And they say that given the circumstances, the stress, the fact that you can only go outside in certain circumstances, they say that being on furlough right now is much more like being on sick leave rather than being on annual leave. Because, although annual leave obviously doesn't mean for everyone going to the beach or going off on holiday, it should at least mean, a period where you can have some decent free time and not just on the couch. That's their view. The contrary view from some others is that the right of an employer to direct when an employee takes annual leave remains the same. And it's really just an employee relations issue about whether you want to force your employees into that. So that, I'm afraid that's just something that there isn't an answer for at the moment. I would say the more cautious approach is to not force your employees to take annual leave unless that's an absolutely necessary thing to do. Yes. So, and the final thing on annual leave is holiday pay. This, thankfully, is now clear. So employees can take annual leave whilst on furlough. The question, as I said, the question is whether they can be forced to, but they're certainly entitled to. And whilst they are on annual leave, whilst on furlough, they are entitled to 100% of their pay, but you can claim, as the employer, you can claim the 80% of that back up to a maximum of £2,500 a month. So whilst an employee is on furlough, they can take annual leave, they have to get their full pay, but you can claim some of it back from the government. Next slide, please, Hina.
Sure.
Now, a couple of interesting issues, I think, about the employer's duty of care. So one thing is about what special considerations apply when an employee is pregnant. So again, as lots of you will know, at all times when an employee is pregnant, employers have additional duties to protect their health and safety. And so that requires assessing the workplace risks, altering the working conditions or hours of work to avoid any significant risk, where it's not reasonable to alter those conditions, trying to offer alternative work, and if that's not available, suspending the employee on full pay. Now, in the circumstances of COVID-19, although pregnant women have specific vulnerabilities, they do not fall within the category of being extremely vulnerable under government guidance, and therefore they cannot be shielding. So they're not in the same category as the people I was talking about with autoimmune diseases or with severe respiratory illnesses. So they're not shielding, and therefore they're not entitled to SSP. However, as I said before, pregnant workers do have vulnerabilities, and therefore they have been strongly advised to socially isolate, avoid traveling on public transport and working from home. So that then creates a difficulty because it places pregnant workers somewhere in between those two things where they're not shielding, but in most circumstances, it might be unsafe for them to come into work. So there's a couple of options that you can take as an employer to try and protect those workers. One is to furlough them, because it seems to be pretty well recognized now that you can furlough anyone where that arises from a COVID-19 related issue. So even if you've got work for them, my view certainly is that pregnant workers can be furloughed, and that way you don't have to pay them. They will get pay from the government up to £2,500 a month. The other alternative is that you would have to suspend the employee on full pay, in which case you would have to pay. And briefly, what should an employer do where an employee who is at work starts displaying symptoms? This is pretty much common sense, but basically the government guidance and the ACAS guidance says that if someone at work becomes unwell with a new or continuous cough or a high temperature, they should be sent home and advised to follow the stay-at-home guidance. I think the key thing here is for employers to bear in mind their responsibilities to that employee, to other employees around them, and to the wider public. So it is not in anyone's interests to require an employee with symptoms to keep working, because of course at that stage they could start infecting others. And it's just going to be a terrible business decision, quite apart from the human cost of it. Next slide, please.
Sure.
Now, moving on to this tricky issue. So if an employee refuses to work because they have a disability, which they believe puts them at a serious risk of illness or high risk of serious illness if they catch coronavirus, can an employer dismiss them? Or if not, what pay are they entitled to? So, as I've already said, people who suffer from certain health conditions are at higher risk of serious illness. So people with severe respiratory illnesses or things like that, or autoimmune diseases. And the key thing to bear in mind here is that if that condition amounts to a disability, which it probably will, whether it's autoimmune disease or severe asthma or cancer in remission, that's likely to count as a disability under the Equality Act. And therefore, all of those issues which you would usually think about in respect of disabled employees really come to the fore here. Because as soon as an employee is regarded as disabled, you have to be very careful about subjecting them to any detriment. So a requirement for that employee to work contrary to government guidance could almost certainly amount to disability discrimination. In my view, it would amount to indirect discrimination because you're applying a PCP of requiring employees to work, and that puts disabled people at a particular disadvantage. And I think it's highly unlikely that you'd be justified in doing that. Frankly, I think there is no circumstances in which a vulnerable employee to work to be justified.
Sorry, can I just remind you to mute your microphones? I think we're hearing someone getting some water. Okay, thank you.
Yeah, sorry. So I was just saying that I think there's almost no circumstance in which it would be justified to require a vulnerable employee to put themselves at risk of dying because of coronavirus. It doesn't matter if your business is almost going bust. I just think that you can't justify that. And so I also think that requiring an employee to work in those circumstances or missing them or subjecting them to a detriment for not working would be discrimination arising from disability as well. And I think you'd probably have a duty to make reasonable adjustments in order to ensure that that employee does not have to come to work. Now, of course, if there's some uncertainty about whether that employee is disabled, you're of course entitled to seek medical advice and medical evidence to confirm that they have that disability that puts them at risk. I think that's the first thing to do if there's any uncertainty, and whilst you're doing that, err on the side of caution. So, I mean, there's obviously lots about being kind during this time, and I think that although employers are under unique pressures because of the financial impact of COVID-19, I think it's really important to bear that in mind as well when you're dealing with your employees. And so I think that's really my approach with high risk employees, is they are entitled to not attend work if that puts them at risk of getting serious COVID-19. And I don't think you're entitled to dismiss them for not working. And I think that as to the final issue as to what pay they would be entitled to if they're not working, that's back to that issue where either you can furlough them, in which case they would get 80% of their salary up to £2,500 a month, or they'd be entitled to statutory sick pay. And I think now over to Ian Rees-Phillips. Next slide.
Yeah, so just we're going to hand over to Ian Rees-Phillips from Six Month Court to talk us through the coronavirus job retention scheme, or furloughing.
Hello, everybody. Hi there. So basically, this is probably something a lot of you will have heard about. It's being used, I've gotten the sense, by far the most out of all of the schemes that the government has announced to support business employers and employees in the course of the COVID-19 crisis. It certainly seems to be used a lot more than, for example, the government-backed loan schemes being able to be used because of banks being slightly reluctant to cover the 20% shortfall in the guarantee 80% that the government was offering. And it certainly seems to be much more widely available than the various self-employment schemes that the government has introduced. So it's of pretty strong significance. In personal experience, I've given quite a bit of advice about this, even if a lot of that was based on government guidance rather than legislation before it was actually forthcoming. And personally, I know of a lot of people who've been furloughed. It seems that of all the law firms that send me instructions, essentially all of their support staff have been furloughed, leaving just the fee earners at work at the moment. So it's definitely something that is highly relevant. It's definitely something that it bears knowing about, and it's definitely something that I think a lot of people will have a lot of questions about, particularly how it interacts with traditional employment law, if I can call it that, because it tends to sit alongside, if not outside, of the way that a lot of employment-related concepts work historically. So I'll start, if I may, by talking a little bit about the case involving Carluccio's. So you may or may not have heard, the end of March, Carluccio's, the relatively well-known high street Italian restaurant, went into administration. It had been suffering relatively significant poor trading for a little while. A lot of high street restaurants have been suffering through essentially an oversupply of that type of business. And the coronavirus lockdown basically pushed it straight over the edge immediately and into administration. Now, the key thing that was relevant for when this matter came to court was essentially the administrators who'd been appointed applied to the court for directions because they didn't know what to do in the context of the, at that point, only announced and not even legislated for job retention scheme. And the important point was that there was a 14-day deadline, wherein in any administration, it's incumbent upon the administrators to work out exactly what contracts within the business they're going to adopt within 14 days. Otherwise, if they allow, for example, an employee to carry on working and carry on being paid, that person basically becomes a preferential creditor at the expense of the other creditors of the business. So what you commonly see in administrations is, as soon as the administration kicks in, you see all sorts of redundancies, because the administrators don't want to keep people in work if eventually they're going to be made redundant, because their redundancy packages would then be preferentially treated as it compares to other creditors. So the important point for the administrators to check was that they didn't know how to treat the job retention scheme insofar as how it interacted with their ability to keep people on the books of the company. What they didn't want to do is be liable for all sorts of people's full pay as preferential creditors if, for example, the furlough scheme wasn't going to support them, or if allowing people to be furloughed would effectively be treated as those people going in as preferential creditors entirely. So what they applied to the court for was some directions. The HMRC had published the guidance, but not any legislation, even in draft form, about 4 days earlier. And essentially, it had been announced by the Chancellor that what HMRC was intending to do, what the Treasury was intended to do, was to allow the PAYE scheme to pick up the slack of basically paying back employers up to 80% of full pay for placing staff onto a furlough scheme, wherein they were going to be not given any services, not providing services for the employer, and thereafter to allow them to carry on being employed. So what the administrators had to do was to work out who they were going to keep on. They sent out notices to all of the current employees, which was about 2,000 or so, to offer variation to their terms and conditions. And this is, frankly, one of the key things within the furlough scheme, is that there's no, because this is a brand new concept, there's no pre-existing legislation that gives an employer any right to engage furloughing. And it's very, under very limited circumstances, I can imagine that many employment contracts had the concept of furloughing within them, because it was just a brand new concept. There's always been statutory layoffs where there's provisions for a certain amount of pay if there's not work for you to do, but you don't want to make it a redundancy. But it's very rarely engaged in normal times, because a lot of the time people don't want to face a layoff with very low pay. They would rather be made redundant so they can go and find work elsewhere. So, but where there was going to be a guarantee of at least 3 months worth of pay, even at 80%, and the alternative was redundancy, with the idea being that once we come out of the COVID lockdown situation, we should be able to move forward, perhaps not quite to a normal life, but certainly something that's a bit more normal than the present circumstances. It was perfectly attractive for a lot of employees. And so one of the things to bear in mind that's important with the furloughing scheme generally is that it's a proposed variation of terms and conditions. So in effect, it's up to the employer to say, look, I'm proposing furloughing. I need your written consent to this, effectively as a variation to your terms and conditions. The alternative to doing this is that we will then have to make redundancies, because the only reason that furloughing is allowed to be engaged by the HMRC rules, which have been announced, was by way of the government's intentions when the case came forward, but have now been legislated for, is that if you're put on furlough, essentially the hoops that have to be jumped through is that you have to be placed in a position where, because of a serious impact upon the operations of the business, there's not work for that person to do. And one of the conditions of being on furlough is that the employee is not allowed to provide any services. So as a quid pro quo, the government will then back up 80%. And a lot of employers have said, well, essentially, I'm willing to keep you as an employee, I'm willing to furlough you, but what I'm going to have to accept in return is that you cut 20% from your wages and accept the 80%, so that the government guarantee covers the entirety of what I have to outlay to keep you on the books. Otherwise, we'll have to make redundancies. So HMRC announced this, or a Chancellor announced this 4 days later. This case came forward, and what the court had to decide was whether or not the variation which the administrators had proposed was something which either had changed the terms and conditions for the employees in the first place, or what was required from the employees to amount to an agreement to those variations, and how that actually interacted with the insolvency aspects of the law that the administrators were engaged with. So what the employers, the administrators sent out was a notice saying, we propose furloughing you, because the alternative is that we're going to have to effectively make redundancies across the board. And what we propose doing is that if you agree to that, please respond. And we need a positive response. Now, they had some people who responded positively, some people who said they prefer redundancy, and some people who didn't respond at all. And there was a bit of debate in the case about whether or not positive response was required in order to treat somebody as agreeing to being furloughed. And there was a bit of discussion that maybe you could do it by inference. That's since been changed, and the Treasury has now published guidance on the 15th of April saying that any agreement to furlough has to be obtained in writing from the employee. So it is now a positive obligation. So if you are in a very large organisation and proposing or have proposed to have made lots and lots of employees on furlough, you may wish to go back and retrospectively make sure that your paper trail is covered in respect to making sure you've got positive agreements to that in writing. And the guidance does say that email will satisfy that. It doesn't have to be a formal agreement or a formal document with a signature on it and so on. And the key thing really with the furloughing scheme in its entirety is to make sure that people's wage security is maintained. And so ultimately the decision when it was forthcoming with Carluccio's for the purposes of the administration aspects was, and of course I realise this may be of relative significance, relatively small significance to quite a few of you, because I doubt there's very many of you that are working at the moment in companies that are actually actively in administration. But the contracts will be adopted when the administrators made an application under the scheme in respect of those employees or made a payment to them under the varied contract. And at that point, the consenting employees that were engaged on that would then have the high priority that I spoke about a minute ago. So the key point really on a broader scale is that if you are going to have somebody who's going on furlough, they remain an employee, they remain employed by the business, and the way in which they are treated is effectively as an employee who has been agreed to a temporary variation in their terms and conditions. And I think it's very likely that even if the agreement to furlough that's been agreed with the employee, even if it doesn't mention anything about any sort of cut-off or an end point, it's very likely that it will be taken to have been implied that that should end one way or the other as an agreement when the government support on furloughing stops. So, Hina, could we move to the next slide, please?
Yes, absolutely.
Thank you. So just some basics, really. The people who are covered, full-time employees, part-time employees, agency employees, flexible zero-hour contract employees, apprentices, and that would cover anyone who falls within those other brackets. So, for example, someone who works within the UK but is a non-UK national, and someone who effectively is working here. Largely, if you think about it on the basis of somebody who falls within an employee terms, not within an employment context, but within a tax law context, because the important defining principle here is somebody who falls within the PAYE system. So it's a little bit relevant to the kind of sense of thinking about things that we were thinking about in normal times for when IR35 was coming in, because looking at a lot of self-employed, looking at a lot of people operating via personal service companies, they might be treated for PAYE, but they wouldn't be employees. And that's the important distinction for the purposes of the Treasury. However, it is wider than that. It's not just people who are current employees. As you may have heard, it's also people who left employment within a certain specific period of time. So it has to have been the case that somebody who left employment for any reason, including redundancy, since the 28th of February, if they're re-engaged by the former employer. I'll come back to that topic in a minute, because that, I think, is the one thorny issue that employers have to be really careful about. So if somebody is on unpaid leave, they can't be furloughed unless the unpaid leave started after that date, the 28th of February. Now that's, for example, to cover people who, for some whatever reason, are unpaid leave, like, for example, unpaid parental leave or something like that that's been pre-arranged. In effect, what the government, I think, or Treasury didn't want to happen is those people who've already agreed to that before all the COVID-19 matter arose, coming back onto the payroll, getting the windfall of having 80% of their pay covered and doing exactly what they might have been doing before, whether that's looking after children or whatever. If an employer has more than one job, their employments are treated separately for the purposes of furlough, and each employer has a separate cap for the purposes of reimbursement, so up to the 80% of their wage, up to £2,500. Someone who's on a fixed term contract can be furloughed. Their contracts can be renewed or extended during the period without breaking the terms of the furlough scheme. And where the contract ends because it's not extended or it's terminated by the employer, then the grant ends for the purposes of the employer no longer receiving it from the Treasury. And you may have seen that in the last week, I think it was Monday, the scheme opened to allow people to make applications with the idea of payment being forthcoming by the end of this month, if people are operating a PAYE pay at the end of the month, for example. So in effect, you'd have seen that by its very nature, people were furloughed almost immediately. Employers have had to pay out to those people if salary has been due in the meantime, and it is then claiming it back retrospectively, with the idea being that for the next couple of months, for the duration of the scheme, there'll then be in effect prospective claims. So the grant can be claimed by other types of people as well. So directors, for example, A director who's furloughed can still do work within the bounds of their directorship obligations. So, for example, filing accounts of Companies House and things like that. But it is quite a narrow definition of director's duties. So it is not going to cover, for example, anything involving management or the like. Anyone who's a salaried member of a limited liability partnership. I mentioned agency workers, but that includes people employed by umbrella companies. So if you've got an agency worker who's working via a PAYE scheme within a company but is employed on an umbrella basis, it will still be the PAYE company that will be entitled to claim the grant. And one of the matters that was initially a bit of a concern was question whether workers were covered. Now, the important point, as I touched on earlier, is whether or not whether they're a worker or an employee within the context of employment legislation, but whether they are treated as a worker for the purposes of PAYE. And that a lot of those concepts that are relevant there do certainly overlap with employment concepts, because a lot of tax law, insofar as who's an employee who should be on a PAYE role, is forthcoming from old employment law. But it's not quite the same, and it's up to HMRC and the tax tribunal's jurisprudence really to determine that question. But to a large extent, if you're on PAYE, you should be covered. Now, the second question on this slide, does the individual have to be at risk of redundancy to be covered? So the circumstances or the hoop has to be jumped through in order to actually furlough someone was initially announced in slightly conflicting circumstances. So it's probably best to start with the underlying basis for the scheme, which is to help employees whose operations have been severely affected by COVID-19 to retain employees and protect the UK economy. That's what the Chancellor announced. However, what the Treasury included later in the same article that came out, which is effectively all we have at the moment, is the right on the part of employers to claim under the scheme is dependent on different impacts on different businesses, that being recognised by the Treasury. However, it's not a specific alternative to redundancy or layoff, but there does need to have been some kind of severe effect upon the employer's business. Now, where an employee is shielding or staying at home because they're living with somebody who is shielding because they're vulnerable, particularly vulnerable to the coronavirus, for example, they can only be put on furlough if they would otherwise have been made redundant. So I think there's a little bit of a tension here, because firstly, you've got there's no specific requirement for a particular employee to be in danger of redundancy in order to be put on furlough. What is relevant is the employer's operations generally have to have been severely affected. So there's not a causal link between the operations themselves and a particular employee being affected. So that may mean that actually in reality, this is going to be a very easy hoop for a lot of employers to show if and when Treasury ever comes and checks this point. In effect, all it will have to show is a severe effect. It doesn't have to necessarily show that a particular employee is in danger of being laid off. However, there is the scheme on the new business support website, which came into effect after Treasury's initial guidance was published, does refer to those who would otherwise have been laid off, and says that it's there to safeguard workers from being made redundant. So there is a bit of a tension here. Now, you then have to try and square that with the idea that specifically Treasury has said that employees who stopped working due to redundancy after 28th of February, so that's people who've been dismissed because redundancy would have ended their employment contract, can be re-engaged and placed on furlough. Now, that I think is quite an important factor, because in effect you've got to look at somebody who would have been made redundant. But I personally think that you may have to, in order to be absolutely safe as an employer, think about people who have been made redundant because of a severe effect caused by coronavirus. Because I don't think that the way that it's treated at the moment would allow you to say, take an employee who's made redundant because your business operations are generally on a downturn and that role is redundant, to be re-engaged solely in order to be furloughed, when if at the end of it, you wouldn't have ever re-engaged that person if the scheme didn't exist. And that's why I think there has to be a bit of a careful tread. You really do have to show some kind of severe effect on business in order to get through the hoop of being entitled to do that. But I think, as I said, that if Treasury ever does call in to check on this point, showing the severe effect on the business is not going to be tremendously difficult in circumstances that many people are facing. So, Hina, can we have the next slide, please?
Absolutely. Can I also remind you to mute your machines? Thanks.
So how to decide how to implement, who to pick, rotating, furlough, and then topping up. The short point is, I think a lot of people will largely have done this exercise by now, but it's useful for the purposes of making sure there's not, for example, discrimination or something like that, that this is thought about. So I would say that some kind of objective criteria for furloughing is probably useful. I imagine in reality a lot of this was done sufficiently quickly in the circumstance of how things happened immediately after the lockdown, that a lot of businesses took decisions relatively in haste and may have to retrospectively go back and check who's liable for furlough and who's not now. But the important thing to point to is that this is one of the areas where traditional employment legislation will get engaged. So if you have adopted some kind of discriminatory criteria, then you should think about how and why that's being used. So for example, if you're picking people for furlough based on being over a certain age, say over 70, and therefore particularly maybe vulnerable to coronavirus, you would have to think about making sure that you positively made sure that you said, well, we're doing this, but it is part of a legitimate aim of protecting those employees' health and safety, and we've identified that on the basis of government advice. Rotating furlough is relatively straightforward. The scheme works on the basis that somebody has to be furloughed for at least 3 weeks, and that's a minimum amount. If you want to bring somebody off furlough and back into work, and then back on furlough again, that's absolutely fine, but they do have to then be furloughed for another 3-week period again. So it makes sense to rotate people through furlough so that you don't have a sort of sense amongst those who carry on working of some kind of grievance that they are carry on working while others are sitting with their feet up. But the important point is that if you are rotating, you do have to just make sure that the minimum 3-week consecutive period is maintained. And then topping up the remaining 20%, employers are perfectly entitled to choose to do that. But they're also perfectly entitled, when proposing furlough, because it is a voluntary variation to terms and conditions, where the alternative is effectively a redundancy procedure, to put to employees that they would wish to propose as part of that variation that the 20% doesn't get topped up. Now, that consent does have to be given, and the employee has to agree to that, because otherwise that would be an unlawful deduction from wages. But it is important to the employee to realise that if that consent isn't given, A, they'll carry on working, but B, their role may well be redundant, because the employer will then be funding the entirety of the pay rather than being allowed to recover at least 80% of it. Okay, Hina, can we move on?
Yeah.
Thank you. A few questions about working during the furlough scheme. Can you work during the period in which you're on furlough? Yes, there's some guidance which was updated on the 4th of April which confirms that. However, the employee can't do work for the employer who's seeking the reimbursement under the scheme during furlough, and they can't be asked to work for another associated business or linked business during that. So it's important also to remember that because somebody is remaining an employee, they're not ceasing employment in any fashion. Any restrictions they might have on working elsewhere will continue to apply. So if, for example, there's a term in the contract requiring them to give their full attention to the job or something like that, then that would apply as well. But it may well be something employers will wish to relax if somebody does have an alternative role. Volunteer work is perfectly fine. The guidance clarified that. The furloughing purpose is in order to protect the employees. Oh,
Sorry, just ask you to mute your machine, please. We can hear
somebody's on the phone. So the important point is that can't be volunteering for the benefit of the furloughing employer. So you can't, for example, furlough somebody and then ask them to come back to work for you on a voluntary basis. And then training, the guidance says that yes, you can claim for the furlough scheme whilst also undergoing training, but the important point is the training can't be used by the employer to generate revenue as a way of circumventing the point of furlough leave. So, for example, if requiring training is somehow going to bring forward some kind of revenue-raising benefit to the employer, they're not entitled to do that. So I think we've dealt with most of those points. If anybody's got any specific questions in the chat, though, I'll quite have to come back to this at the end. Thanks, Hina.
Okay. So, right, we're now going to move on to a case study. Now, I'm going to discuss this one, I believe, with Paul. But a bit of background might be useful. We've had a few cases that fall into this category, but one in particular where a senior manager decided he would not allow his team to go to a major exhibition with, I think, over 1,000 people. And he didn't want them to travel to this event because of the COVID risks. Now, everything has moved so fast that at that time, we weren't on lockdown, and so it was still a case of deciding whether it was going to be safe for these individuals to travel. Now, he took the decision based on fairly reasonable advice from a senior level, sort of guidance, to not send his team of about 6 to this group, 3 of whom had some serious underlying health conditions. And then as a result, very shortly afterwards, despite never having any issues at work, in fact winning awards and being highly celebrated, he ended up called into a room and told that there was an issue about personalities. He had less than 2 years service and he was sacked. Now, this looks very much like a health and safety related dismissal, but I'll ask Paul to talk about some of the issues that can arise if an employer chooses to do this. Yeah.
Thanks, Hina. Yeah, so this is an issue which obviously to give you a bit more of detail on the facts of this, as Hina said, this is a case where we were in the pre-lockdown stage, but we were in the situation where, as you know, lockdown had been initiated in other places like Italy and then Spain, and it was starting to look like we were going to be locked down here, but that wasn't the requirement. And this is a situation where really this employee has said that they want to take what they think is the correct view to protect the safety of colleagues or people for whom he or she is the manager, and the business has said no, you weren't entitled to do that, and then because they've said that he's basically acted of his own accord, refused to obey lawful management instruction, and so what they've essentially said is that he refused to obey that, and therefore they terminated him. I mean, as usual in these cases, it's not a situation where they have explicitly said that they're doing it because he's raising a health and safety matter, but as you all know, that's almost always the case in practice, that people don't put it in black and white when they're doing things unlawfully. So, I mean, really the issue here is, and we'll come on to talk a bit later about the issues that can arise where an employee is taking steps to protect themselves from danger. But essentially the position is that under the Employment Rights Act, an employee is able to refuse to attend work or to take certain steps if they think that they or others are in serious imminent danger and they couldn't have been reasonably expected to avert that danger. And this is a situation that's under Section 44 and Section 48 of the Employment Rights Act. So really this is a situation where we would have to look whether at that time there was a serious and imminent danger to his colleagues and himself in traveling. And that's really going to be quite fact specific, because there was a point, I can't off the top of my head remember exactly what date, when the government actually designated the COVID-19 pandemic as a serious and imminent danger. And so at that point, you'd think it's a pretty slam dunk argument that the employee can rely on that provision and therefore shouldn't be subjected to a detriment because of that provision. If it was before that point, it's a bit trickier, but it may also depend on things like where that flight was due to go to and how possible it would have been for people to socially distance, what the guidance was at that time, etc., etc. I mean, really, this is a perfect example of what I was talking about earlier, which is trying to treat people with compassion in these cases, where they're acting to try and protect the health of them and colleagues, trying to treat them with compassion. I think this was a case where the senior manager at the company was a bit of a skeptic about the effects of COVID-19. As you all will remember and know, there are a group of people that still think that COVID-19 is just like the flu and its effects are overplayed, and that you can use bleach to cure it, which you should not do. But frankly, an employment tribunal looking at that type of situation is just going to think, was it reasonable for that person to refuse to obey that instruction? My view is that it almost certainly would have been, and therefore that a dismissal would be unfair, and probably automatically unfair, because it's probably connected with a health and safety issue. I think, we can move on to case study 2, although it's a pretty similar issue which arises, but I'm happy to talk that through, or for Ian to talk it through as well, whatever suits.
Just to jump in quickly to say that obviously so much of all of this will depend on the evidential trail when things are covered up, and that's where I think that the weaknesses can come out. Sorry, so the next one, who's doing this one? Is it?
I'm happy to do this one as well, just because it's on almost exactly the same issue, just with a slightly different tint to it. So this is where instead of trying to protect others, really, this is somebody who sort of walks out the office because they're scared that another employee has coronavirus. And again, it's the same legislation that I was talking about before. So really, in these circumstances, I think that there would be a good chance that an employee could show that they were refusing to attend work because they reasonably believed that they or others were in serious and imminent danger, and they couldn't have been expected to avert that danger. One of the key things to remember when you're looking at health and safety dismissals or detriments is that what matters is the employee's belief as to the danger. And sorry, I mean, some of this.
You can mute your machines because we can hear you.
Thanks. Yes, so even if you as the employer think that your workplace is totally safe and there's not a risk, everyone's socially distancing very well, if an employee subjectively thinks that that's not true and they're at risk, and if that subjective belief is reasonable, then that's enough. It doesn't matter what you as the employer thinks. And danger is going to be widely interpreted in these scenarios. So it could be, for example, colleagues not socially distancing, or colleagues remaining at work with symptoms. So my view is that in those circumstances, we as an employer, you'd be well advised not to take detrimental action against somebody who's walking out of the office over these sort of fears. I mean, really trying to establish some good communication. You would really hope that it wouldn't come to the stage where an employee has to just walk out, but you would hope that there would be able to be some communication about that. So yeah, I hope that's helpful. I think case study 3, which we can move on to, I think Ian might be able to take.
Yes, Ian, would you like to just briefly touch upon this, and then we can move on to the mental health?
Yes, absolutely. But I mean, all of these things are linked, really, because we're all looking at making sure that health and safety is maintained. All of this is novel. The important point is that usually what is not always the case, but in this case, the legislation largely seems to reflect common sense. So in the case study 2, it's quite obvious that somebody who's in a position where they're forced to work where there's not sufficient social distancing, or they're near to someone who's displaying obvious symptoms or something like that, will be able to take action. In relation to wearing masks, at the moment, government guidance suggests that wearing masks wouldn't help an enormous amount, except unless you are symptomatic, because the point is that it protects you. It protects other people from you coughing, essentially, rather than protecting you from breathing in other people's coughing droplets. But one of the things that the current public health guidance suggests is that they don't recommend the use of face masks as an effective means of preventing the spread of infection. It may well change. I think an employer at this stage within the UK would find it difficult to support the compulsory wearing of face masks. I don't think that would be tremendously likely to fly. But the important point is that if, for example, somebody has raised this as an issue, it's not always going to be the case that the employer is going to be able to sustainably defend, in hindsight, the fact that that person didn't have an imminent belief in some sort of threat to their health and safety. However, it's a balancing act, because you don't want to then threaten somebody with a refusal to obey instructions or what have you. Usually the better way forward in a situation like this is to find some means by which that person can work from home, or the person who may be symptomatic works from home or wears a mask or something like that. I think, frankly, if somebody is symptomatic and is displaying some kind of symptoms and wants to wear a mask, they should be allowed to. But it's a balancing act, and I think it's important to make sure there's an element of common sense here.
Just to jump in there, Ian, very briefly, I think it might be slightly cynical of me, but I think that there's a very good chance that the government guidance on wearing masks is going to change pretty soon. We've already seen the Scottish government announce that people should wear it on public transport or in crowded spaces, and we've seen that the WHO announce it, and we've seen others. So a cynic might suggest that the UK government is just waiting until we have enough masks to tell people to wear masks. So I think, like Ian says, the more cautious thing is always going to be the best thing. You know, the costs of wearing a mask are really low, and if it helps people stay healthy, then it's likely to be a sensible thing.
I think the important point is that, you know, you've got to look at how you may be able to defend this action in hindsight, and you've got to try and work out therefore where the guidance might go, given that it's a bit of a moving situation.
Wonderful. Good. So shall we move on then to the final case study? I know that, Paul, you may need to leave us a little early, which is fine. So yes, now we're going to look at a very interesting associated issue, which obviously with the kind of things that people are suffering and issues at work, mental health becomes a much bigger concern. And I think what we'll do is allocate a whole session to this the next time we do one of these webinars, because I know it's a very important area. So we don't have too much time, but I'm going to ask Ian to talk, because he actually assisted us on a case involving suicide, potential suicide or actual suicide, but in a more general sense, just to talk you through some of the issues. There is a case study here which you can see, and if you maybe take a look at it, it's just to help you give a framing for these issues. But the thing I want to say before I hand over is simply that remembering that mental health is a form of sickness. It's someone at work who is unwell, and so to remind you that when you're looking at anyone with any kind of illness, that there are principles of fairness that apply, and that's basic unfair dismissal protection and laws and guidance. So you do need to remember to consult employees, do return to work, get medical evidence. So that still remains really important. Then there's another level that you can go to, which involves disability. Could that mental health condition amount to a disability? And if that is the case, you then have to start looking at more issues like reasonable adjustments, and there are higher risks that you have to face because there may well be a potential discrimination claim. Now, stress and mental health can give rise to potential issues relating to personal injury, which is kind of a separate area of law, but related. Same as if you injured yourself at work because you tripped, but you know the way that the kind of stress that you've been subjected to, or the manner in which you've been made to work, has led you to have a mental breakdown or some sort of mental injury. And so there are all these different levels. Now, one thing to say is that there are guidelines on how to assist employers in avoiding a claim in relation to stress. But looking specifically at the issue of suicide and some of the concerns in this case study, first of all, the fact that suicide could actually amount to a disability. Now, remembering the definition for disability is someone who has a substantial adverse, an ailment which has a substantial adverse effect on their normal day-to-day activities. So just the fact that someone is suicidal could satisfy that definition. And so what I think is probably a good idea, looking specifically at this, is looking at some of the issues about what you can really do. Could you contact their family? Could you let people know your concerns? And what are some of the issues around this? So if I just hand over to Ian to discuss this.
Yeah, so it's a sort of thing that cuts across a number of different disciplines. It's not just an employment law matter. That's sort of the main context this will appear in. But certainly, as far as the issues of law go, it's quite interesting from a number of areas. So one important point to bear in mind is that, as Hina said, somebody who is suffering in this sort of way may well very commonly meet the criteria for being disabled. I think it would be a very brave employer to suggest that if they knew of something like this, some sort of threat to kill themselves, that they didn't then treat that person as potentially being disabled and take steps in respect of referring them to occupational health as a matter of urgency, if not ask for some kind of medical evidence from the employee if they still have that kind of relationship. So there's then the importance of making sure there's not discrimination, making sure that there's the taking of reasonable adjustments and so on that you would normally have for any employee suffering from a disability. But one thing this does engage in a sort of an urgent fashion with this sort of scenario, which is unfortunately something which was relatively high profile, the case of Caroline Flack before we might remember earlier in the year, where you've got something with this sort of urgency, another duty kicks in, which is the obligation on the part of the employer under the Health and Safety at Work Act. Now, they've got an obligation to conduct the undertaking in such a way, so far as is reasonably practicable, that the people who are in employment, or even people not in employment who they're responsible for, are not exposed to risk to their health and safety. And somebody suffering from work-related stress or work-related anxiety or depression which is exacerbated by work or some kind of bullying, harassment, all of those sorts of issues, then you may well have a responsibility under the Health and Safety at Work Act. Now, traditionally, that would apply in fields like heavy industry, transport, machinery and things like that. But I think the modern way of looking at mental health is that you've got to value the mental aspect of well-being just as much as you would the physical aspect. And so it's important to bear in mind that not only might you have employment law rated obligations, but also obligations under the Health and Safety at Work Act. And I think specifically in the context of trying to warn somebody about this issue, particularly where this sort of urgent situation like this, you're then engaging aspects in relation to data protection and confidentiality. And it's important to bear in mind that under the Data Protection Act 2008 and under the 2018, and also under the GDPR, which the DPA 2018 brings in line in UK law, if there's a real risk to a person's health and safety or some kind of life-threatening situation, then that because of the obligation upon you as both employer within the bounds of employment legislation such as the Equality Act, and under the bounds of the obligation of the Health and Safety at Work Act, and I'm sure some of you may or may not be aware there are a very wide number of regulations that also apply to specific industries in relation to the Health and Safety at Work Act. If you think there's some kind of life-threatening situation, or you think there's some kind of issue like that, and in order to make sure you comply with that obligation on you, you have to responsibly or reasonably release that information to a third party, such as a public authority like the police or a healthcare professional or the individual's family members, then it's perfectly fair to do so without breaching any Data Protection Act obligations. So I think in the circumstances of this particular case study, I think the employee would find it very difficult to allege that there's been some kind of breach of data security because that information has been released in the urgency of the situation. I think people who make those sorts of threats should be prepared for people to take them seriously, frankly.
Wonderful. So yes, just to therefore, thanks very much for that, Ian. Thanks so much, Paul. Just really to bring this to a close, I just have a couple of things to say. First of all, thank you so much, everyone, for attending. It's been wonderful to have you here. I know that we normally share a cup of coffee and have a chat, but obviously we have this is the only way we can do these things now. We will be sending over a feedback and testimonial form, so please do complete that, and we'll be having another one of these fairly soon. Final point, if you have any questions at all, please email us. We'll be uploading some guides onto our website and letting you know about them very shortly as well. But other than that, thank you all very much for attending.